Hello, this educational video is brought to you by the Colorado HOA Information and Resource Center. The topic of this video presentation is Meetings of the Association. The information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. Types of meetings. There are two main types of meetings for HOA associations: owner meetings and board member meetings. In this presentation, we will discuss both types of meetings. The Colorado law that specifically addresses HOA meetings is found in Section 38, 33.3, 308 of the Colorado Common Interest Ownership Act, commonly known as Kiowa. Owner meetings. What is an owner's meeting? The Colorado Common Interest Ownership Act provides that a meeting of the unit owners shall occur at least once a year. An annual meeting is the most commonly referred to owner meeting. Generally, consideration of matters that require owner votes are discussed, such as those usually held for election purposes, like the election of board members and officers, budget approval, amendments to governing documents, and other important matters of interest to the association and its members. Notice of the owners' meeting must be given not less than 10 days and no more than 50 days in advance of any such meeting. The secretary of the association or another officer specified in the bylaws shall cause the notice to be hand-delivered or sent prepaid by U.S. mail to the mailing address of each unit owner or the owner's designated address. The notice shall also be physically posted in a conspicuous place for the owners, which is both practical and feasible. And this is in addition to any electronic posting or electronic mail notices that may be sent out. The notice shall state the time and place of the meeting and the items on the agenda, including the general nature of any proposed amendment to the declaration or bylaws, any budget changes, and any proposal to remove a member or officer of the executive board. The law requires that agendas for owners' meetings be provided to and be made available for examination by the unit owners. Can the association cancel or reschedule an annual meeting? Annual meetings are required under the Kiowa law. So if you have an annual meeting in the near future and need to cancel it for the year, you will have to reschedule it. If you reschedule your meeting to a later date, you will still need to provide proper notice for the rescheduled meeting per your bylaws and Colorado law. As an alternative, if you move forward with the meeting that you were considering rescheduling due to unforeseen circumstances, you might want to consider setting up a call-in line for participating by speakerphone or Skype or other telephonic or video conferencing method. Colorado law allows members to attend meetings by telecommunication as long as the members can hear each other during the meetings. Now, let's talk about an association's board member meetings. What is a board member meeting, and who can participate in the meeting? The board meetings are for the board, and the owners' meetings are for the owners. The discussion of official business for the association is done in a board meeting by the elected board of directors and its officers. These meetings are also commonly called executive board meetings. The Kiowa law also provides that owners or their designated representatives shall have an opportunity to speak at a board meeting on an issue prior to the board voting on that issue. However, decisions are made by the board and not by the homeowners. The board may place reasonable time restrictions on owners speaking during that meeting. All regular and special meetings of the association's executive board or any related committees are open by law to attendance by all members of the association or their designated representatives. The law also requires that agendas for board meetings be reasonably available for examination by the unit owners. There is no requirement that the board provide notice to the homeowners of board meetings unless provided in the governing documents. The Kiowa law is silent on the notice requirements for executive board meetings. Can the board hold a meeting remotely? Yes, association boards can hold meetings remotely, but they must still follow meeting requirements under Colorado law. To hold a meeting remotely, you should consider the following. Everyone needs to be able to hear each other simultaneously. Board meetings are still required to be open to owner attendance, other than when in executive session. So if an owner asks for the sign-in information, you should provide it to them. You do not, however, need to provide the telecommunication device for them to access the meeting, but you do need to allow the owners the opportunity to attend the meeting remotely. If any owners decide to attend remotely, please note that before the board takes any action on an issue, owners are entitled to speak on that proposed issue. Other than during owner forum and prior to taking action, owner participation can be limited. Many online meeting devices allow remote attendees to be able to observe and hear, but not to speak until the appropriate time. Check what features your online system has so that you can control owner input at the appropriate time. Board member executive sessions. What is a board executive session? Executive or closed-door sessions are held by the board in private to address certain matters. The board is only allowed to meet privately for specific purposes, as set forth in the Kiowa law in Section 38, 33.3, 308, Sub 4 of the Colorado Revised Statute. Colorado law allows the executive board or any committee of the board to go into executive or closed session and can prohibit owner attendance for the following matters. Matters pertaining to employees of the association or the managing agent's contract. Also, consultation with legal counsel regarding disputes, and privileged and confidential information between the attorney and client. Also included as limited executive session matters are investigative proceedings concerning possible or actual criminal misconduct, and matters subject to specific constitutional, statutory, or judicially imposed requirements protecting particular proceedings or matters from public disclosure. Finally, the other matters that can be discussed in an executive board session include any matter the disclosure of which would constitute an unwarranted invasion of individual privacy, and the review of and discussion related to any oral or written communication from legal counsel. Prior to the time the members of the executive board or any committee convenes an executive session, the chair of the body should announce the general nature of the discussion as enumerated in the statute. The executive board can allow attendance of other persons as requested by the board, such as their attorney, committee members, employees, or certain homeowners. The right of a member to speak prior to any action being taken by the board of directors only applies to meetings of the board that are open to the members, unlike in an executive session. No rule or regulation of the board or any committee of the board shall be adopted during the executive session. A rule or regulation may be validly adopted only during a regular or special meeting after the body goes back into regular session following that executive session. The minutes of all meetings at which an executive session was held shall indicate that an executive session was held and the general subject matter of that session. Usually the minutes of an executive session do not state the details of what was discussed during that executive session. A Colorado law does allow associations to withhold executive session records from inspection by owners. This is found in Section 38, 33.3, 317. Special meetings. When else can the owners meet and vote on certain matters? Special meetings offer another forum where owners can take action. These meetings must be limited specifically to the issues outlined in the notice of the special meeting. Proper notice of the special meeting must be given to the unit owners. A request for a special meeting may be made by the board president, a majority of the board members, or the unit owners having 20% of the votes in the association, or by a lower number prescribed in the association's governing documents. Also, within 90 days of the board adopting a budget, the association is required to have a meeting of the unit owners to consider the budget. Unless provided otherwise in the governing documents, homeowners don't have to ratify a budget, but are given the opportunity to veto the budget. Decisions can be made outside of a meeting as long as it doesn't conflict with the law or the governing documents. However, boards should be cautious to engage in board business in the absence of a meeting. Homeowners should also be sympathetic to the fact that some urgent matters may need to be dealt with in the absence of a meeting. Boards need to check their bylaws for any restrictions and review the Nonprofit Act for any requirements. Be cautious in the absence of a meeting. Here are some additional pointers regarding meetings for board members. Can owners vote by proxy at an owners meeting? Yes, owners can vote by proxy by signing an appointment form, either personally or by the member's attorney-in-fact. An owner must provide notice to revoke a proxy, and proxies are only valid for 11 months after they are given. Speaking procedures at an HOA meeting. At an appropriate time determined by the Board of Directors, but before the Board votes on an issue under discussion, unit owners shall be permitted to speak regarding that issue. The Board also may place reasonable time restrictions on persons speaking during the meeting. Frequently, however, problems and disputes arise at meetings between board members and the membership. Having meeting procedures in place can assist with running an efficient meeting. One method that can be used to run an efficient meeting is the use of parliamentary procedure. At the heart of parliamentary procedure is the rule of the majority with respect for the minority. The objective is to allow deliberation upon questions of interest to the association and to arrive at the sense or the will of the membership upon these questions. Everyone should have an opportunity to speak at an owners' meeting at the appropriate time, but in a well-mannered way. Parliamentary procedure, or more commonly known as Robert's Rules of Order, is specifically designed to help debates and discussions go smoothly, especially when you have a large number of people or contentious issues. It helps to ensure that everyone in such a meeting gets a fair and equal opportunity to participate and speak, utilizing formal motion procedures. The use of Robert's Rules of Order can require that everyone who wishes to speak must sign up to do so. Provide that if a vote is to be held on an issue, speakers must sign up on either the in favor or against list. Have speakers present their position in the order that they sign up, and then alternating between in favor or against points of view. Also allow people who wish to speak a second time to be called on after everyone has had an opportunity to speak once. Robert's Rules of Order can also allow for a timekeeper or parliamentarian who can be in charge of time limits for speakers and to make sure that speakers stay on the issue at hand. It can limit the length of time that an individual is allowed to speak on an issue, for instance 2 to 3 minutes. It can also require formal motions and seconding of motions, as well as properly amending those motions. This has been an educational presentation from the HOA Information and Resource Center. Following this presentation, you will find a short quiz and some HOA resources. Thank you for watching.